Hello, continuing on with topic 7, capacity, let's talk about a special kind of contract with miners. That is a contract for necessaries. So what are necessaries? Necessaries are essentially basic needs: food, shelter, clothing. So the things that you need that are necessary for sustaining life, but they can include goods or services that are essential for the reasonable comfort of the miner. And the cases take into account the miner's position in life, drawing on some very old-fashioned language there. The Goods Act, Section 7, has picked up that language and provides, in the context of saying that it's a requirement that a miner pays a reasonable price for goods that are necessaries, that those goods are suitable to the condition of life of the miner. So the definition in the Goods Act is a really good place to understand what a necessary is. The case law instead is focused on two issues: whether the goods or services are necessaries as a matter of law or whether they're necessaries of fact. So let me explain that in a little bit more detail. Have a look at the case of Scarborough and Sturzaker, a 1905 Tasmanian case, and it's in your textbook, or referred to in your textbook at part 810. So it provides this authority for the proposition that goods or services, in order to be necessaries, then the miner must not already be adequately supplied with that thing. So in that case, a miner needed a bike to get to work. So he traded in his old bike, took the new bike, and promised to make a subsequent payment. Subsequently, he said, no, I'm not going to pay for that, and claimed that because he was a miner, he didn't have capacity to contract, therefore he shouldn't be held to the contract. Ultimately, though, it was found that in this case, this was a contract for a necessary, and so as a matter of law, he could be bound and held to the contract. Why was it a necessary? He needed the bike to get to work, and because he had traded in his old bike, he didn't have the old bike, so he didn't have that necessary thing available to him at the time that the contract was entered into. You can compare this case with the case of Bojczak and Gregorcewicz. The chances of me pronouncing those titles correctly is completely unlikely. This is one of the cases that's also referred to in your textbook at paragraph 810. In that case, the plaintiff paid the fare for an 18-year-old defendant who was a minor to come from Poland to live in Australia. The defendant promised to repay the amount, but ultimately failed to do so, and she claimed that the contract wasn't binding on her because she was a minor, and the plaintiff claimed, well, that it was a contract for necessities or necessaries, so it should be binding on her. The Supreme Court of South Australia held that the contract wasn't a contract for necessaries, that she didn't need to come to Australia. Sure, that the status and the situation of life and her status would be better in Australia than it possibly was in Poland, which was part of the Iron Curtain at the time, or behind the Iron Curtain, I should say. But she did not come to Australia for the purpose of providing herself with a means of self-support. She already had a job in Poland. She didn't need to leave as such. In that case too, the Supreme Court of South Australia looked at the question of whether she came to Australia for obtaining instruction. So it overlaps slightly with beneficial employment contracts, which we'll talk about subsequently. And ultimately found that, well, she didn't need to come to Australia for instruction either. And the fact that the contract was beneficial to her didn't make it one for necessities or necessaries. So as a consequence, she couldn't be held to the contract, and she didn't have to pay the amount back. One issue of contemporary relevance that's received quite a lot of attention is whether a motor vehicle can be a necessary. I think you're going to start to see a bit of a theme here. If you need it, it's necessary. If you don't need it, it's not likely to be so. So in some of the cases, a motor vehicle hasn't been found to be necessary, but where it has been needed, for example, as part of somebody's employment, then it will be found to be a necessary, and when the contract relates to necessaries, the contract is binding. So necessary services can include legal, medical and educational services. The kinds of services that will be necessary will depend very much on the person's situation and station in life. So when is something a necessary? What have we learnt so far? We basically have to apply this test. We need to ask ourselves, is it capable of being a necessary? Can it be properly regarded as a necessary for this particular minor? So to start off with, it needs to meet the threshold test. Is this something that's capable of being a necessary? Is it something that goes to food, shelter, education, ability to perform employment services? If it does fall in that basket of things, then the next question is it properly regarded as necessary for this particular minor in these particular circumstances? So we take into account what the nature of the item is, the minor's station in life, and then also whether the minor is already sufficiently supplied. The next question that arises is who can recover payment for necessaries that are supplied to a minor? Essentially, that's the trader who supplied the minor direct, and any person who buys necessaries for the minor at the minor's request and on the minor's actual or implied promise to pay for them. However, there's a trick for young players here. Lending money to a minor, even for necessities, at common law, a lender has no right to recover. In equity, a lender can recover the amount as the minor actually spent on the necessaries. So it's one thing to buy necessaries for a minor, and then you can recover that amount. But if you lend the minor money, and the money, on the basis that the money is to be used for necessaries, the only amount that you'll be able to recover is the amount that was actually spent on the necessaries. And this is augmented now by statute. It's the Supreme Court Act that's relevant. So let's go back to our framework for considering contracts with minors. So we've asked ourselves the question always, are all the elements for formation present? If they are, then we ask, is this a contract involving a minor? And is it a contract for necessities? If it is, then the contract will be binding. So it will be enforceable both by the minor and by the other parties to it. In the next little video, I'm going to move on to beneficial contracts of service, so I'll see you there. Questions, of course, as usual, email, discussion board, or bring them to class with you. Cheers.